Affirmative action has been a controversial topic for several decades. It's as controversial as ever today. Affirmative action is practiced by many actors in society, including private educational institutions, private and public employers, and others. We only have time to discuss the topic of affirmative action in public higher education. The place to start is with a case I didn't ask you to read, Regents of the University of California v. Bakke. The University of California at Davis Medical School instituted a minority set-aside program. In the entering class of 100 students, 16 seats were set aside for disadvantaged minorities. Alan Bakke, a white man, was rejected, despite scores and grades exceeding those of minorities who were accepted. Bakke sued under the Equal Protection Clause of the 14th Amendment. Before the Supreme Court decided the case, Ronald Dworkin wrote the article you were assigned. Although Dworkin supports the goal of affirmative action programs, he believes that they must be invalidated if they violate constitutional rights. He argues, however, that the Davis Plan does not violate Alan Bakke's rights. He notes first that no provision of the Constitution explicitly bans affirmative action. But Dworkin is quick to admit that the absence of specific language in the Constitution doesn't settle the matter. The Equal Protection Clause, Dworkin believes, protects a right of political morality. It protects equality, understood in a particular way that only moral reflection and argument can clarify. Dworkin believes that Bakke is effectively claiming that he has a moral right not to be subjected to the Davis Plan, and that the Equal Protection Clause should be read as giving legal status to that right. So Dworkin asks what the content of this alleged right might be. He considers first the idea of a right to be judged on one's merit. But merit has many components: how much effort one expends, how much natural talent one's born with, and how much market demand there is for the specialty one chooses to pursue. A prodigy who doesn't work hard may lose to a student of average abilities but greater dedication. Schools don't admit applicants as a reward. They admit applicants whom they think will best serve their purposes, for whatever reason. In any case, the Constitution certainly doesn't require public universities to admit students on the basis of talent and effort alone. Bakke could claim that he has a right to be judged as an individual, but this can't be correct. All admissions procedures use generalizations for administrative necessity or convenience. Many schools have minimum GPA requirements for interviews, although these cutoffs disfavor some who would have been better doctors. Some students who scored too poorly on the MCAT to be admitted would have made excellent doctors. No one has a right to be evaluated using perfect predictors of success, because no such predictors exist. What Bakke actually claimed at trial, however, was that he had a right not to be excluded from the set-aside seats because of race alone. This is the most interesting claim, but Dworkin rejects it rather quickly. He thinks the right we have is actually more complex than this. It's a right not to be disadvantaged in competition for public benefits because one's race is the object of prejudice or contempt. We can reconstruct the argument like this. A policy that disadvantages someone in competition for public benefits because of his race does not for that reason infringe his rights unless his race is the object of prejudice or contempt. The Davis Plan disadvantages Alan Bakke in competition for public benefits because of his race. However, Bakke's race is not the object of prejudice or contempt. Therefore, the Davis Plan does not infringe Bakke's rights in virtue of disadvantaging him because of his race. Bakke is excluded, Dworkin suggests, not because those who instituted the Davis Plan have contempt for the white race, but because of a judgment that Bakke is less likely to serve the medical school's social purposes, as well as a disadvantaged minority applicant. The Supreme Court of the United States, however, did not accept Dworkin's argument. Dworkin believes that public institutions infringe no rights if they decide on the basis of race, regardless of their reasons for doing so, unless they do so because the disfavored race is the object of prejudice or contempt. That's why a school that excludes blacks for racist reasons violates the Equal Protection Clause. But Dworkin accepts whatever social agenda the Davis Medical School might have, as long as it's not a racist agenda. The Supreme Court, however, struck down the set-aside plan. Justice Lewis Powell was the controlling vote in the case, and he rejected 3 rationales for affirmative action, all of which the Davis Medical School had endorsed. The first of these is reducing the historic deficit of minorities in higher education. Justice Powell rejects this rationale. Second is countering the effects of societal discrimination. Powell rejects that too. Third is increasing the number of professionals in underserved minority communities. Powell only validated one reason to maintain race-based affirmative action programs at public institutions. This is known as the educational benefits of diversity. Powell reasoned that the First Amendment protects a university's right to create a more educational climate for dialogue by diversifying its student body. However, even a university that relies exclusively upon that rationale can't use the Davis Plan. Instead, the court suggests approval of a plan used at Harvard University and many others. On this plan, unlike at UC Davis, there's no set-aside. Every applicant's considered for every seat. But race is factored in as an advantage in admissions, along with other non-academic criteria. Dworkin thinks there's nothing wrong with a rigid race-based set-aside, provided that it's not motivated by prejudice or contempt. By contrast, Powell thinks a race-based policy can violate rights, even if no prejudice or contempt is alleged. It's not obvious, however, how Powell reached this conclusion. If the educational benefits of diversity are good enough to justify the Harvard plan, why not the Davis Plan? And if the Davis Plan is unconstitutional because it's explicitly race-based, despite no allegation of prejudice or contempt, then why is the Harvard Plan okay, given that it's also explicitly race-based? Despite these lingering questions, the Supreme Court upheld the Bakke ruling in the case you were assigned, Grutter v. Bollinger. The Grutter case also confirmed that the Equal Protection Clause allows public universities to use Harvard-style affirmative action plans, provided that their only rationale for doing so is to generate the educational benefits of racial diversity.